very much, Catherine. So, of course, you're here. So, Dmitry,
Hello,
how are you?
Vikram. Hello, everyone. I'm well, thank you.
But
Good to see you and all colleagues who are listening and hearing and watching us.
but I think Dmitry, the mustache is good. Mustache is a good change.
Yeah, this is my new feature.
No,
Mustache
no, no. I think it
was
really is
not
a good.
yeah, introduced by myself a few weeks ago.
Very nice.
Yeah.
No, I think that's,
So,
so that's a good change. Good change. So what we have to do, Dmitry, is let me just put up what we are doing here. I need to put that up here, which
uh-huh.
is, of course, the mediation legislation, right?
Yeah.
Now, the thing is that, of course, I put out these questions because I just felt that, I mean, of course, we have to question every aspect of it. I mean, let's not take it as a given that, okay, this is what it is. Let's look at it how, I mean, if you want mediation to progress, so we need to look at all that, question every aspect of it. That's what it's all about. And of course, Dimitri is going to tell us about himself. So, Dimitri, you want to tell us about yourself and then give me 30 seconds to maybe put up the whatever I do, how to find information, right?
Uh-huh. Well, I'm a legal practitioner and legal researcher. I was born in Minsk, in Belarus, and educated in university in Russia, in Moscow. I'm a PhD in law, and I speak, apart from Russian and English, also Italian, French, and German, and Belarusian. So I'm very interested in comparative law studies and all related fields of study, not only jurisprudence. And my center of legal practice and research is private international law and international commercial dispute resolution. My PhD in law was exactly on settlement agreement in comparative perspective in law of several jurisdictions. So I'm in this field already about 19 years, and I do not regret it. I often practice as an arbitrator in various disputes, mostly international, from various countries, under rules of International Chamber of Commerce and various Russian arbitral institutions and some others. The topic of my speech today is an overview of legislation governing mediation in Russia and in Belarus.
But before that, Dimitri, can I just give me 2 seconds to put up my website to just tell people to find information there? Is it all right with you? Can I take
Yeah.
that 2 minutes, 30 seconds? I won't take 2 minutes also. I take 30 seconds because I just go to mediatorvikram.com. Please find information about the work I'm doing, connect, all everything is here. And of course, the World Mediation Circle, this is where focus area has to happen. But World Mediators Conference is coming up in May. So that's about it. The last year's work, this year's, all that information, all YouTube links and everything is here. So you just click that, you can get the details of whatever, the playlist, everything for the YouTube channel has everything. So Dimitri, that's of course what it's all about. Please. Yes, but only thing, Dimitri, I don't know, you speak so many languages. I should call you whenever I need someone because sometimes I have people who don't speak the other language. They don't speak English. So I should bring you in. That's now you've told me.
Okay. Well, yeah. So first of all, the general overview of legislation and partly of practice mediation in Russia. The beginning of the first years of Russian Federation, 19 90s, that was a time where mediation was already practiced, or even without a developed legal basis. The only legislative acts which provided for possibility to settle a case through mediation were the Commercial Procedure Code and the Labor Code. However, this did not create an obstacle for those people who studied, who learned how to mediate disputes, to do it successfully, in particular corporate disputes, various family business disputes, where all disputes where the parties were involved in lengthy relationships were good for this procedure. And in early 2011, the mediation law was adopted, which is currently still in force. And its aim is to assist the establishment and development of business partnership relations. This creates a legal framework regulating different crucial issues such as confidentiality of mediation, immunity of mediators from testifying at courts as witnesses, and the validity of mediated settlement agreements. The law defines mediation as a method of dispute settlement with the assistance of a mediator on the basis of the parties' voluntary consent, aimed at reaching a solution mutually acceptable for them. The mediation law governs different aspects pertaining to the mediation of disputes which arise from civil law relations, commercial, labor, and family law matters. And 8 years later, it was also specifically provided that even public law disputes, administrative disputes, may be settled by mediation. However, this is yet only a kind of a purpose for the future, not a reality. Public law disputes face great challenges for mediation because public officials need special authorization to take part in settlement of disputes in order not to be blamed with corruption. So to settle a dispute with, for example, taxpayers or with businesses. However, there are already some good examples of settlement of claims from state antitrust body against companies where the related dispute was settled by amicably. The Mediation Act, Federal Mediation Act, which I'm speaking about, is not fully based on the UNCITRAL model law, but many its provisions still have the same practical meaning. What are the differences? The law specifies that if a dispute affects or can affect public interests, then it may not be mediated. Means that if there is a dispute between two persons, but the subject matter is important from the state perspective, then this may result in not availability of settlement of the dispute, which means that it needs a court decision. Unlike the UNCITRAL model law, the Russian Mediation Act distinguishes between professional mediators and non-professional mediators. Non-professional mediators may not publicize themselves as mediators, but may help parties to settle the disputes from time to time, not as a part of their job, but simply as a supplement to some other activity. It may be a business person or a lawyer. However, the existence of a category of non-professional mediators was heavily criticized these years, because people from time to time call themselves mediators, and this may create a wrong impression for general public. As a result, the trust to mediation can be undermined. Also, the Mediation Act introduces a notion of mediated settlement agreement, so it distinguishes it from other settlement agreements. The main difference was introduced later, or in 2019. Since that year, if the parties wish so, they may notarize the settlement agreement, and it will become directly enforceable. So this is a special privilege for mediated settlement agreements. Unlike almost any other contracts do not enjoy such regime of direct enforceability, except for some agreements on alimony payments, for example. Apart from that, there are provisions about mediation in procedural codes, in civil procedure code and commercial procedure codes, that judges shall take measures to conciliate the parties, that parties may use any procedure to settle their case, including mediation, that the courts shall suspend the consideration of the case for the time necessary for mediation, but this time must not exceed 60 days. So that's the time for the parties to try to settle the case by mediation, and then the court resumes the proceedings. The possible results of various settlement proceedings, including mediation, are also specified in the procedural codes. They include settlement agreement for all or part of the claim, then other agreements confirming certain facts, and revocation of the claim, admission of the claim, and other. So that's how it is with legislation. Mediation is mentioned in several other acts, including Family Code. Apart from that, it's important to mention that today there is a time when the state initiates legislative reform for mediation. Mediation, as it is said, is not frequently practiced in the country, and also there are complaints regarding the quality of the procedure of mediation, because, for example, there is no requirement for mediators to undergo regular training. So there is only a requirement to receive a training under the program approved by the Ministry of Justice. But once such training is over, there are no more requirements even for professional mediators. There is no code of conduct for mediators. There is no public register of mediators. So it is a problem to complain against a mediator who somehow conducts the procedure with violation of law or his duties. So what is, for example, a few days ago, on 13 April, there were parliamentary hearings in the lower chamber of the federal parliament about the use of mediation in socially significant areas, including restorative mediation and family mediation. It was organized by the special committee of the parliament on family, women and children, with the support of Ministry of Justice. And there were many representatives of legislative, judicial, executive authorities, public associations, professional community of mediators, academic institutions. The Ministry of Justice announces that the reform of regulation of mediation activity should include not only restorative and family mediation, but all kind of activity, that it needs to be streamlined. First of all, it is planned to approve standards and rules for the professional activities of mediators. Then the parliament is going to determine the state authority authorized to develop and implement state policy and legal regulation of mediation. And also creating a public register with information about mediators and organizations which carry out activities to implement, to practice mediation providers. Such are the main directions of the planned reform. Indeed, the currently statistics show that settlements occur very rarely in comparison with millions of disputes resolved by state courts. So the case load is extremely high. For example, in general courts, annually about 20 million disputes are considered, and mediation is registered only in a few thousand cases, which is of course very low. For example, there are mediations, successful mediations in family disputes, land-related disputes, consumer relations, labor, and inheritance disputes. However, statistics, of course, shows only, I think, a small part of true number of mediations, because most of them are confidential and never reach the public domain, as it is something which is practiced, if successfully, then usually it does no need. The mediation settlement agreements do not need to be registered anywhere. The Chamber of Commerce practices mediation under its aegis, including intellectual property disputes, corporate construction-related and transportation disputes. And 80% of people, of applications to mediate are initiated by judges, state judges. So most often it exactly the state judges who well recommend the parties to try mediation. It is interesting to say that the law reform, legislative reform currently underway in Russia was already implemented in Republic of Belarus. There is already a public register of mediators, well, code of conduct. So practically the changes planned in Russia are already existing in Belarus. So also the Singapore Convention is effective for Belarus, not effective for Russia. As regards other differences in legislation between the two countries, well, I would mention that Belarusian legislation expressly provides for enforceability of international settlement agreements according to the Singapore Convention and also to the procedural legislation. In other respects, there are many provisions which are common, I think, for many countries, such as confidentiality of the procedure, the duty of mediator also to be confidential, and that mediator may not be arbitrator between the parties unless the parties expressly authorize the mediator to arbitrate their dispute. So in principle, it is not excluded, it's possible in both countries. If the parties wish, so mediator may become arbitrator in their case. The law in both countries expressly provides for possibility of the mediator to for a caucus meeting with separate meetings with the parties. The law also provides that the professional mediator must have a higher education, any higher education, legal or any other, and the special training as a mediator, according to the program established by the Ministry of Justice, or as the Belarusian law says, mediator would need to have, it may be a person who has an experience as a judicial conciliator, according to procedural legislation, because judicial conciliation is a related procedure of dispute settlement existing in particular in Belarus for many years, and it brought many successful settlements of cases, so it still exists in parallel with mediation. That's practically what I wanted to say on this matter. If you have some comments or questions, Vikram.
Yes. Dmitry, with your academic background and everything, what you have to tell us is, how do you see what legislation should be like? That's going to be the biggest thing to look at. And of course, you looked at the model law, you looked at maybe other countries. So what is your structure of legislation?
For me, legislation. Mediation is such an activity which does not require, in my opinion, much legislation. Only essential standards, essential provisions which help parties and the mediators and public to be sure, to feel trust in this activity. In particular, that the enforceability of the agreements to mediate, then I think that requirements for the education and special training for mediators, that's also important. Some sort of public register, I think that is also helpful, meaning that there should be some possibility of party to complain, or maybe praise to the particular mediator, the duty to undergo training from time to time, probably. Also, witness immunity of mediators is essential. Confidentiality of mediation and the enforceability of settlement agreements. Also, international enforceability of settlement agreements is very important. And the authority of the courts to take into consideration the parties' failure to take part in mediation while allocation of the judicial costs. That probably would be reasonable. There are some general provisions to this effect, in particular in Russian law. And I think that's something logical. So I think that more or less that's how it should be.
Because look, Dmitry, what you have to look at it, I mean, how I'm looking at it is that let's just look at it from the global perspective. We have a Singapore Convention out there. Of course, Russia is a signatory, India is a signatory, not ratified. But at least a framework is developing. And in that framework, mediation can happen anywhere. It can be enforced in a country that has ratified it. That's the global situation. Now, when we look at it from the mediation's perspective, domestic as such, any dispute, should you or can you not bring in someone from outside to be your mediator? Should there be a restriction on people to bring in? Because at the moment you create these steps, entry barriers. Now the entry barrier means that you've limited, obviously, the people's choice. Should you be limiting people's choice? I mean, this is their dispute, whoever they trust. Should it be done? Or what do you feel about that?
I'm grateful for you that you have reminded me about this problem. That there is for me, it's a problem that the status of foreign mediators is unclear, or it's not recognized at all. So, of course, people should have a right, in my opinion, to choose the mediator. It may be a mediator educated and trained in some other country. Why not? As a general rule, that should be allowed. And currently, this is, I think, as far as I understand, not sure, but I think in many countries it's not the case. So you just need to choose between the national mediators from the same country. Yeah. So there need to be some, I understand, international agreements about standards of qualification mediators in order to recognize the status of foreign mediators?
Because that's where I think the starting point by itself, I feel this is where why issues will come up and are coming will will come up because there's not too much activity there. But the point is that everyone will want to create entry barriers, and there are vested interests who want to create entry barriers, because obviously you want in your country that your institution would should be recognized as the one certifying mediators or training mediators, so that
Yeah,
becomes
sure.
your vested interest. Now you would no one wants to let that go if it's open for everyone. You can choose whom you want. So I'm saying, for me, on one end I am saying yes, it should be choose anyone you want, because it is your dispute. Who is anyone to tell you whom you trust? If they trust anyone, it's their choice. Now on the other end, you want that, okay, there is some kind of maybe uh, maybe a database. Let's look at a database or a pool of mediators from whom people can choose. So we have two aspect parts. They already have someone who they trust, and the other, they're looking for someone they can choose as their mediator. So the on this side where they trust someone, why should be anyone, be the government or anyone, come in to say, no, you can't trust this person? I mean, it just sounds illogical to me. It's simple, Dimitri. Finally, it's the way governments want to get into people's lives. You have a dispute with someone, you bring in third person into your living room, can come sit with us and help us resolve our dispute. Should the government be entering your living room to see whom you are sitting with? I think that's where it starts with that kind of a control kind of thing. We want to control what you do, whom you sit with. Do you think from that perspective, do you look at it that way?
Mm. Yeah, I think that indeed there should be an opportunity for the parties to choose the mediator. So that's indeed, I would agree with you on that.
Yeah, because once they trust someone, all those issues, other issues go away. Because it's their person. Now, on the other hand, now we're looking at that there should be a pool available from whom people can choose someone. So now, how do you want to regulate this? How do you want to do it? Because one option is that whoever wants to act as a mediator, the details are put up, and from those details, or maybe a little video clip of the person, because look, finally, to have trust in someone, you're not only going to, of course, look at their qualifications and everything. You will interact with the person, but to interact with the person, first step can be, okay, you watch a little clip and you know the experience. Isn't that good enough for the way mediation is structured, that you interact with someone and then you think, okay, I can trust this person, and then that information goes to someone else with whom you have a dispute, and that person out of all these people also agrees on someone. If two people can agree that yes, this person seems to be someone we can bring in, isn't that good enough a quality assurance kind of thing?
Mhm. I think for commercial disputes, at least, that should be because of the professional status of the participants, which should be able to choose the mediator. Yeah.
Because I'm looking at it that it's not about anyone has to have a certain qualification. You choose, because look, looking at what kind of dispute you have, everyone will have different kinds of dispute. Where did they come from? I mean, it's their choice of the person that they have want to choose. So if there is this whole thing that we need to just put these names up there and the information up there, and has to be, I mean, look, finally, I'm just saying, even the fact that in your mind, what should a mediator be? I think people would not even have that. What should a mediator be like? They don't have any idea. So it's the person they're connecting with. I mean, I'm just looking at how where legislation can come in this kind of thing. What do you say? Like in what Ashian was saying, from Turkey, you have to be a lawyer. Now imagine, now you already limited the pool that out of only you can choose out of this pool of people. So this limitation will start coming in because someone will say, oh, this qualification is a must. But is any qualification required? That's, I think maybe that's the starting point, maybe.
Yeah, it's not an easy question. On the one hand, yes, that should be the party's choice. On the other hand, if there are experience shows that there are many abuses from people who really are not qualified, meaning they are not true mediators. So after people have experience of mediation with them, they lose trust in this procedure. So the harm is kind of also significant. So there should be some sort of, I don't know, certification of quality, that one person is certified as a mediator, and so you can be assured in the quality of his or her activity, professional activity. Another is not. So if you choose the second one, okay, but it's your own risk. You must be informed about that.
But what will be the criteria to certify? And who will certify?
The training of mediators, the mediation, in my opinion, has the good thing with it is that the standards of its conduct are probably more or less the same in the whole world. If we look in the Singapore Convention, we see the provisions on that if the mediator does not conduct it even-handed to the parties, and well, provisions to that effect, then it may even become ground not to enforce the settlement agreements. So there is a duty of mediators for the procedure, and it requires certain skills to conduct, and skills should be learned. So like there are other professions, experts in various areas of human activity, which are now somehow regulated with certification. So maybe the same way with mediation, because mediation is also a technology, with special rules how to do it. The success of each mediation mostly depends on whether these standards or these technological steps are fulfilled. So I think that training and certification as a result of training is possible internationally as well, not only nationally. I know that even now there are some institutions in Europe in particular which certify mediators internationally. Although my general position is that mediation should be as free from interference as possible. So only the necessary minimal standards, essential rules, essential regulations. So the most problematic of them is exactly this, how to ensure the quality, whether there should be some control or training. It's really something mostly problematic. That's why we are
It's about, yeah,
discussing it.
no, because it starts with the basic thing, like you said, on control. It's control. Does everything, every human interaction to be controlled? Should we do it? I mean, is it the right approach? Because that's why the symposium on colonization, decolonization, and mediation. That is that what the mindset is, that we must get into every aspect of human interaction. Because I said, next, what will you certify? You'll certify mothers. Otherwise, you can't be a mother up till someone doesn't certify. How do you certify a mother? Who is there to say that this is what is the requirement? This is an interaction, individual interaction. So I'm looking from this perspective. The other side, you say there are organizations in, say, Europe who certify. Now, have they shown any success in relation to the development of mediation? Because I always give the example of UK. There are 18,000 mediators there certified and everything. Only, I mean, someone says 500 have worked, someone says only 200 something have worked. So all that is, these are money making rackets, I would say. So they're scams. I call it a scam because they're telling people, yes, we are making you a mediator, but on the other end, then no work is coming to them. So it's very, I mean, these are nice things to put out there, but these institutions also will now, the vested interest that they are also going to influence legislation. They will say, this is the certification that is required, which will be their certification. So what the, I mean, of course, the legislators will fall into that trap. And this is where we come into, does everything need to be certified? Let's look at the people who are the legislators. Let's look at that. I don't know, Dmitry, about Russia. In India, a person to be elected to be a legislator does not require any qualification, no certification, nothing. It is the trust of the people. Now the
Yeah, I think
legislator, yeah, for the legislator,
not
you're
only
okay.
in India, I think in most countries, yeah,
Exactly. I'm just saying that I know it's in most countries. And that is what you have to do. You have to leave the choice to the people whom they trust. I'm okay with that. Now, similarly, I'm saying about the mediator, it is their trust. Now, the legislator doesn't need to be certified, doesn't have to have a qualification, but the legislator will make a legislation about whom you should trust. I will certify. I'm just saying that this is how we have to approach it. I'm approaching it from this angle, that everything doesn't need to be a certification training. It is a matter of, if it has to develop, it will develop on people's trust, and it will be word of mouth. It will be a word of mouth activity that, yes, there should be enough of those positive kind of experiences available, which is where the problem is. It's like chicken and the egg. Those experiences are not available, so people are not talking about it. If they're not talking about it, the word of mouth of the mediator doesn't spread, that who is that mediator in your community or in your business community or whatever. Because yesterday we had that, we were having a discussion from the Ecuador. Gabriela and Jimena were there, and they're saying now that it's like a critical mass has developed there. There is no court mandated mediation there, but mediation is really successful there, because now people, it's about experiencing it. People have experienced it. They are taking it up as something they want to do. So there's so many positive experiences available there. Because of that, at least if there is some, like you said, maybe a mediator is not, I mean, not the most professional or not the most ethical or whatever might come up. These are the things you want to look at. It doesn't affect mediation because there are enough positives available there. So I think these negatives that people are wanting to look at without any mediation happening. Oh, what will happen? What? How will people perceive it? They'll turn away from mediation. They're not using it now. What are they going to turn away from? They're not using it. So to find ways for them to use it. How do we let them use it if we already are going to limit whom they go to? They can't go to the person they want to. There's obviously, it's a dispute. There's confidential aspects that they want to discuss. There's so many things that you want to maybe just, I mean, just maybe throw out some ideas, bring in ideas. Are you going to do it with everyone? I mean, I feel that it has to develop on a very different level, and that's where I talk about my World Mediation Circle and grassroots activity. I do not want legislation to come in the way for that. So for me, that is one, think of it, my vested interest, that legislation should not affect people from choosing whom they want to start with, because I want them to identify those people. And if there is a problem in a legislation which says, no, you can't go to this person, that'll be a problem. So
Yeah, I see your point very well, and I share, mostly I do share it. Perhaps there should be some voluntary registers, voluntary certification, voluntary ways to prove your personal skills, something like that.
yeah,
Yeah.
look, in a way, the way, let's say, the market will decide. The point is that once a person gives a good experience to someone, and they find out, okay, this person is connected to this institution or had this training or certification, whatever happened, they'll connect it with that good experience. Then those things can take off. I'm for me, I everyone thinks I'm against all these institutions doing the training and all. I'm saying let people see the benefit of the work first, then look at these aspects of someone wanting to develop their skills. They want to go to an institution, they want to do it, that can be their enhancement of their skill, or maybe a recognition of what work, how I mean, say a part of a panel somewhere or whatever. That can be something that can benefit people and even the mediators once there is some activity happening. There is no activity happening in most countries, and we are already wanting to regulate something, and actually if there was something that may happen, may not happen because of that. So I think we have to be very careful when that legislation has to happen, if it has to happen, and how much of it has to happen. But I totally agree with you on these aspects, that
Mhm.
confidentiality, enforceability, mediator not being called in as a witness, and of course the without prejudice, it should be without prejudice. These are
Mhm.
things that definitely, that these are things you can look at legislation to give that confidence to people, that yes, this is not going to be used against you. So you can go into it without that issue. I mean, those are things, yes, you need to do that. But beyond that, I don't know how this is something that of course, I'm against, and that's why you will have to talk about the model law, because you have studied it. From the model law, from the UNCITRAL model law, are you okay with it? Do you want to take out something, add something?
Yeah, I would say that UNCITRAL model law is uh, quite a good model. It contains these necessary elements of um, well of legislation, standards, um, and in combination with amendments regarding international enforceability of settlement agreements, that's already uh, more or less something that is sufficient, more or less, for conduct of mediation. The success of the procedure, in my opinion, does not depend so much on the legislative framework, but rather on the culture of the people, or the way how they are accustomed to settle their disputes, whether they are keen uh, on talking to each other when a problem arises, and, do it early when the problem is small. Well, so it's not something so much about legislation. Like if we compare it with construction, there are numerous norms and rules about construction, should be subject to complicated standards. Otherwise, the building will fall. So mostly technical standards, and people may be killed if this happens. That's how it is with construction. Um, uh, in mediation, of course, technology should be complied with technology in order to bring success uh, instead of worsening the conflict, because unqualified uh, intervention of a third person only makes the conflict worse usually. Yeah. But how to ensure it? Well, there is always a risk. I think this is something which parties have to face, that if they negotiate with the introduction of a third person, a neutral mediator, there is a chance of success. There is a chance that there will be no success, but mostly it's worthwhile to try.
Well, that is what's really happening. And if you look at it, interestingly, there was ASEAN from Turkey today itself, and she's talking about that how for mediators there is an exam that they have to give, and there's training and some constant training kind of something happening. They will have to, of course, maybe talk to her more about that. But He's just saying, and this has to be a lawyer. Okay, a lawyer has to go and give this exam to be a mediator, and there is no bar exam there. So you can practice at the bar without giving an exam, but to be a mediator, you have to give an exam. Now, let me give you from, say, from the Indian perspective in the court system. Outside the court system, I put out that legislation we have. I feel it's really good, taken from the UNCITRAL conciliation rules 1980, simple, choose who you want. So that they're private, outside the court system, private mediation, perfect, damn good. On the court system, interestingly, what it says is that to be a mediator in the court annexed program, you have to have 10 years of experience at the bar. Can you imagine a person can today join the bar and represent someone who's on the death penalty? That's all right. But there is something about mediation that only after 10 years you can sit with people and then only you can help them resolve the disputes. I mean, it's gets absurd over absurd over absurd. I mean, can you imagine? I'm a young guy, can go death penalty, argue the matter. Again, the other thing that's come up is that arbitrators in most countries don't require a qualification. They're not regulated. And imagine regulating mediators where this person is only not making a decision for you, and you can walk out of the process whenever you want. That we need to regulate so much. You don't know what harm this person is going to do. And here, a person is going to pass an order. There's an award which is as good as a court decree. That's all right. We don't need to have any qualifications for this person, nothing at all. You can choose whom you want. Isn't it absurd, Dmitry? What do you think?
Yeah, that sometimes comes to mind. Yeah, but I hope that there will be no special standards and trainings for arbitrators.
There shouldn't be. There shouldn't be, huh? There shouldn't be. Imagine.
Well, they exist, of course. There's some Chartered Institute of Arbitrators in UK and some other countries.
Institutions can create what they want. The government, the law doesn't require that. You can choose whom you want. And this person is passing a code. Let's look at it. Passing a code decree. That's what the person is doing. We don't need to regulate this person. They're perfectly all right. Choose whom you want. It's just that I think what has happened is that basically lawyers are controlling the legislation also, and lawyers don't want to definitely control themselves because they are the ones who are making huge amounts of money from arbitration. They don't want that controlled. So that's, people are getting away with that. I don't know what this thing is about mediators, because first of all, they're the ones who are mediators, who have the mediator mindset, decent people. They don't want to get into the, you can do what you like with us. Don't pay us anything in the court system. We're okay with it. Make all kinds of qualifications for us and examinations, and we're okay with it. So I think somewhere someone has to put some sense into legislators. What are you legislating? This is a process. People can walk out whenever they want to. They're not bound by it. It is their intelligent people. It is their dispute. They will see how much they trust someone, how much information they want to give to this person. They will, that's their, look at it from their intelligence also. They are also gauging someone. And they're not, the person finally, of course, is not passing a court decree. This is your solution. But on the other end, protect confidentiality, protect without prejudice. So at least if you feel that something happens there which a person would otherwise take to court, don't take it against that person. Whatever, without do that. But to get into this aspect of it, I am still finding a little, I don't know, I'm still going to use the word absurd, but I think it is a little getting into more and more absurd, going into absurd directions.
I think you have knowledge, as I understand, about well, maybe not the whole world, but of many regulation in many countries. Is there a general trend to heavily regulate mediators in most countries, or only in some of them?
No, like I said, well, look, on one end, let's look at the Turkish example. Why I'm talking about Turkey is because mediation is doing very well there. But in the sense of numbers, the huge numbers out there. So there was some, she gave the figures, 3 million cases went into mediation. But that's
Mhm.
the statistics part of it. What lies behind the statistics as to why did that matter go into mediation, and if it was settled, what were the reasons for the person to settle? Were there power imbalances there? Was there lack of choice? There was the affordability of litigation, not being able to follow that. So those are behind the scenes, behind the statistics, which doesn't come out
Mhm.
in statistics. So numbers will be there, but is it, I mean, good publicity of mediation happening or not? Is, are you going out happy with mediation? So that only we'll get to know, of course, as time goes on. Right now, numbers are there. So when you look at from there, that perspective, like I said, the first entry barrier, who can be a mediator, that has been created. That a lawyer. That's, for me, that's as heavy as legislation can be. So that's the starting point. Then in that also, these people have to go through an exam. So then the next entry barrier you've created. So let's legislation on this end, which of course uh, I'm looking at. Now look at the Ecuador example, again successful, nothing to do with nothing happening in the courts, but they've created these mediation centers. So you have mediation centers, and then of course you can independently practice as a mediator, but this is only for those situations when you want a court degree. I mean, the settlement agreement is as good as a court degree in that situation. Then you have to have, if you want an individual mediator, then that person has to be certified by the center. So in a way, they've created a center and given a lot of, I mean, I would think a lot of leeway to the center as to whom they're certifying. So that part of it, whether that's good or not in the long run, how that happens, because a lot of centers are mushrooming there. Now, in terms of training that you keep talking, people keep talking about training. When numbers go to that extent, huge numbers are coming in. Whether, first of all, who's training, who's the trainer, who's certifying that person, and how many numbers can you have? I mean, Gabriela herself was giving the example that if she's doing a training, there are 50 people in that training. She says, "What? How do you even? I mean, you what quality of training can you do with 50 people?" She's saying, "On you're doing it online, you can't even see all of them first of all." So a lot of people have their cameras off. So in a way, they've sat through the training. How, what use is that concept? So that part of it also has to be looked at. First of all, who's the trainer, and how is the training process happening? When you have all that in place, then you start talking about certifications if you have to. I'm not saying you have to go that direction, but today you said training, a nice word to use, but what, how is it happening, and who's doing it? That part of it. And first of all, for me, the point has always been, how much do you know about mediation, the process, to say that now you can train someone in this? There is so much about mediation. I've only tried to pick up few things. What topics? I said, I mean, one word that comes up so many times is neutrality. So I had a whole symposium on neutrality and mediation. And I'm saying that debating that one word can be 40 hours, and you say the entire mediation training is 40 hours. So you're just throwing words to people. Okay, mediator is neutral. Heard it? Good. Move on. Next topic. That's not the way you can do training. If you have to do involved training, then you have to get into it in involved matter. And I'm not saying theory is required. This is it's something that you have to practice. I don't need to know all the technical words or all the theory behind what happens. I want to practice it. I want people to experience it. So in that kind of a situation, do we want to fall into this trap of saying you have to know the theory, you have to know the terminology, Bhatna, otherwise you can't be a mediator? Why? He's actually, when he's practicing it, he knows what Bhatna is. Doing it as a practicing thing, doesn't need the technical word around it. So I'm just, that's one part. And then other things that I keep saying, of course, I had to, in this symposium, I haven't used that too much, is the heart soul spirituality. There is so much more in terms of the mediation, the way I look at mediation, that aspect of it. What training are you doing on that? Are you even considering these things? You've got certain theory for certain things available, you throw that at those people, but is there more happening there which is much more than what you even can put words to, maybe? So there is, it's not an easy thing to go and even train someone on it. And I don't think it's, and it's not right, it's not being fair to mediation in that sense, of the way I understand mediation. But we can actually start, we should have, and I've been talking about it in most of my symposia, that why don't we start with first talking about what mediation means to you, and then look at, like in this case, look at legislation after we've kind of spoken about what mediation is. I put it out in my post. I put out a definition of mediation, picking it up from the Singapore Convention, because 55 countries have signed it. So 55 countries in principle have accepted that definition. I look at it from that broad perspective. So I put that out. Otherwise, there is no such common definition available. Every legislation will have it. Indian legislation doesn't have any definition. So, because of course we picked it up from the UNCITRAL model with that conciliation rules. So, I mean, connecting it to a definition, okay, there is a definition available there. But I'm just saying that maybe mediation itself is understood differently. And if it's understood differently, then obviously you look at legislation differently also. So this aspect of it, the way I look at it, that is a much broader concept for me. The other thing is could be in the court system, a settle more of focused on settlement, it seems. So that will be another thing. So Dimitri, from that perspective, also you have to throw some, you put out your thoughts on that.
Mhm. Could you? I was listening to you with interest. You thank you for sharing so many thoughts which originate from your long experience in the field and conversations with many people from the whole world, I would say. If you could summarize the question you wanted or something, what
Look, I
to
tell you
me,
what, yeah,
what
I understand. And I say a lot of things that I go into different directions. I totally, look, let's start with the first thing. We say legislation. What are we trying to legislate? Mediation. What is the understanding of mediation? Let's start with that. Because if you have to legislate something, you have to know what you're legislating. So,
Mhm,
what is the understanding of mediation for you? What would be the understanding of mediation? So, then we'll look at the next step of legislating it.
mhm. Well, for me, it's a method of dispute settlement with the assistance of a neutral person on the basis of the parties' consent, aimed at reaching some solution which is acceptable for the parties.
Because Ajay, why I'm asking you this question is because there are some parts of the world where there is kind of a hands tied of the mediator approach, that a mediator can only do this much and not beyond that. So the one thought process is that the mediator is only going to facilitate, is not going to suggest. So
Mm.
that's
Well,
then if you, yeah,
I think that that would be a strict understanding of mediation. It's good only for a style of
yeah,
mediation. Facilitative is a kind of mediation,
yeah,
but it's of course good to decide on whether it is so. In Belarusian legislation, there is such a reservation in the law that mediator may not, what's the correct wording in Russian or in English, may not recommend the solution, let's say
yeah,
so.
yeah. So in
May
a way,
not,
yeah, yeah.
mediator may not introduce proposals how to settle the dispute. For example, in Russia, mediator may do it if the parties authorize him or her to do it. Maybe that's too much. No need to specify this in the law. But well, we are speaking about cultures, peoples who have very little experience of mediation. So it's kind of trying to breed the culture, to introduce a new culture into the
But
people.
but Dimitri, with this now, like I said, I mean the UNCITRAL conciliation rules try to explain the process there. It's been 45 years since it's been out there. So, I mean, I'm just saying that when is that time? When are we going to say that, yes, now it has been there for a long time? Because it is always discussed as new. So, do we need to in the legislation explain the process? Should you, because you feel that a lot of people might not be aware, it's good to put it in a simple form. But that's what the whole, I mean, idea was, that I think even 45 years back, that let's explain the process. But when you start explaining the process, people have tried to, I mean, I give the Indian example, said we don't have a law on mediation because conciliation, the in that it says that the conciliator may suggest, but
Mhm.
that's not mediation, that's conciliation, that's another process. Not understanding that that had to be put because in certain situations and certain I mean with certain people, they want to suggest, they may suggest, but it's not something that you have to do. They say no, no, that has to have be done. That's what the conciliator does. So they interpret it in various ways to suit their vested interest. So how much do you think should be explained there in terms of the process?
Uh-huh. So I think that the law does not need to specify such details on whether the mediator should or should not give proposals about settlement. It's up to the mediator and to the parties whether the parties want it from the neutral. So kind of neutral evaluation from the mediator. In principle, I do not exclude it if the parties authorize him or her to do it.
Well, Dimitri, when you, like you said, neutral. Now that by putting that word, actually it will be the job of the mediator to explain to the participants in the mediation what neutral means, which by
Uh-huh.
itself is such a difficult thing for mediators themselves to discuss. What is being neutral? So should we be throwing words into legislation which mean actually for the user, it's more confusing? Are we making this legislation for users, or are we making this legislation for someone else to explain to the user? And how are we looking at legislation? Because for me, look, I said, for me, it is a people's process. It has to be something so simple for them to understand. They don't need to go to someone else to interpret it. That's the kind of legislation I would want, so that
Mm.
they use the process. They don't have to first of all go even to a lawyer. They should, for me, I'm trying to create that thing that lawyers you go to at a certain stage maybe, but this is not the first thing that you do. You have to go to the lawyer to understand the legislation. So that's, I mean, I'm just saying that certain things I think maybe should they be there, that the mediator has to be neutral. And who's going to explain neutrality to a user? And if you start looking at the meaning on the dictionary, that will become too difficult for a person to explain to a user. So it's not supporting or helping either side. So
Yeah.
are you
Mhm.
sitting there to help them or not? First of all, you're saying assisting. That's what you start with, assisting the people in dispute. And then you say, no, we're not going to assist you. I'm not going to assist any of you.
So um, kind of assisting both or indifferent to both.
Exactly. How do you explain to someone? You said that this process is such that you will assist us. But now you're saying you're not going to assist us. What are we doing? What are you doing here? What is the whole process there?
Yeah. So
So I think that
I'm yeah. I I heard it frequently that mediator is not to assist parties, yeah, or not, yeah, not to consult parties. And in the end, it happens that it's not clear what the mediator is for, because
exactly.
it's not for, yeah, for reaching. At least the parties often do not understand what is the purpose then.
Exactly. And how do you make a process popular if you don't even tell them what they're going to get out of it? Are you going to get any benefit out of it? So
Yeah.
a lot of these aspects. I think what Dimitri, what you need to do is tomorrow, please come in for the workshop and let's discuss how much we need to put into this, what should we put into it, to and of course looking at it from a process which is I'll always say this, a people's process. It's their process. And without, should there be any interference at all by the government? Of course, the judiciary, of course, for me, that should not get involved. But should there be any such thing? Because of the fact that their self-interest of getting the backlog out. How do you look at that aspect of mandatory mediation as it is developing? You haven't given your thoughts on that, on the
Mm.
mandatory mediation part of it.
Well, thank you for invitation. I will try, unless it is it's at the same time when some other my activities will uh, take place. But thank you, Vikram, for raising important topics, important issues to be thought over indeed. Well, to summarize, I think that very few things should be expressly specified in legislation on mediation, not many of them. There are many problems with mediation, but they do not reach, should not reach legislative level. They should be at another level, the level of society, the level of mediation providers, of organizations of mediators, and so on. So, yeah, probably so.
Perfect. Thank you, Dmitry. Always a pleasure speaking to you, and hopefully we'll see you tomorrow. I'm sure if you can take out some time, you don't have to. You can come in for some time, whatever time you get. Right.
Okay.
So thank you very much, Dmitry, and
Thank,
see you
thank you,
soon.
Vikram.
Yeah. Bye.